Hi, everybody. I'm going to answer the question today. How do patents and trademarks work together to protect you? Hi, I'm JD Houvener, owner, founder, and patent attorney here at Bold Patents Law Firm. I'm also the author of Bold Ideas, the Inventor's Guide to Patents. So I've included that in the Inventor's Kit below. Click that link and download the kit. You get access to my whole PDF of the book I wrote, helping inventors get that leg up on the competition and get started in this complex area of patent law. So let's talk about patents and trademarks and how they're different, but mostly today about how they're working together to help you in a suite of intellectual property to protect your product, solution, and innovation. Patents at its core protects inventions. No surprise. And there are two main types of inventions that they protect for the most part: designs and utility. Designs protect just the way that something looks. If it's unique and novel and non-obvious, you can get a patent so long as you have an article manufacturer, a three-dimensional shape that has never been designed before. The second type of patent you can get is a utility patent. This is where there is novel function. You've invented something that does something for the first time. That is worthy of up to 20 years of protection in the patent law. Design patents, as I mentioned before, those are worth 15 years after the date of grant. Now, trademarks, one of the most distinguishing aspects of trademark is it's not about inventions. It's actually about your brand. As your company and your product enter the stream of commerce, the whole point of what's called the Lanham Act, which governs the trademark law, is to protect consumers, to make sure that buyers, buyers in the market can go pick a product off the shelf, look at it, and they don't have to guess where that product came from, as long as your brand tells them. And over time, they'll get used to the quality and the nature, and they'll have some idea or understanding of what the goodwill of the product really represents. That's trademark law at its essence. And so the federal Lanham Act prevents any confusion. We don't want the consumer to have to, wonder, well, is this brand the same as this brand? Where does this come from? What's the quality of this product and how much should I pay for it? And so if there's any brand that's in the same class or category, and there's many, many classes within the area of commerce, you cannot use the same name or any confusingly similar name, logo, design, or word mark in the same class. That's really the fundamental difference between those two areas of law. Now, the way they work together is by putting together a suite, a whole barrier of IP, intellectual property protection around your product or solution. So let's say you're going to market with a new product. You want to see if what you've come up with is unique, novel, and non-obvious in order to get a patent protection. If you're able to get that, you can have a giant monopoly, a really big market capitalization effort by blocking out, excluding anyone else in the market from being able to make users sell that product for up to 20 years. If you qualify for that, you definitely want to go for a patent. That's going to help you prevent others from entering the marketplace right away. On trademark side, that will actually last as long as you're in business. There's no end date. So for that same product that you're trying to protect for that limited time, you can actually extend the protection after 20 years if you've maintained your trademark registration status. So that's how a lot of these really famous companies survive and are able to still prevent anyone else from really entering the market. Even if they can actually make the same product, they can't call themselves your product name or your company. So really, if you've done a really excellent job in combining the product, innovation, and branding, and been consistent with that message, you can really have your protection extend into perpetuity, so long as you have that product and brand combination of both patents and trademarks working together. Now, there's an additional bonus here, other area of intellectual property called trade secrets, as well as copyright law. And we'll talk about that in another episode. So if you haven't done so already, please click below, subscribe, and then download the Inventor's Kit. That's going to be a free PDF of the book I wrote on Bold Ideas, the Inventor's Guide to Patents, as well as some tutorials, explanations, and charts about what your options are for connecting patent searching and patent application drafting. I'm JD Houvener, owner, founder, and patent attorney here at Bold Patents Law Firm, wishing you an awesome day. Go big, go bold.